Hey, this is David with I'm So Offended. Continuing on with this modification here that we were doing. So, this is part two. There's probably going to be 6 parts, but I just want to help you guys out by walking you through petition to, for modification. All right. So, again, this is not legal advice. I'm not an attorney, and I'm not an attorney, and I don't practice law, and um, this is just for informational and educational purposes only. This is for your entertainment, and I'm not liable for anything that you guys do. All right, so I believe I left off here on the nature and extent of coercion or duress used by a parent in obtaining an agreement regarding legal decision making or parenting time. And that was number which one? 9. Number 9, mother has failed to follow court order and the law by obtaining a passport illegally for daughter, has taken daughter out of state without permission by father numerous times. What I ended up doing is I actually contacted travel.us and I informed them, about my daughter's passport, and I told them that she obtained it illegally, and I put a flag on her passport. So, yeah. So, and then they followed up with an email and told me that they did in fact flag it. Number 10, whether a parent has complied with Chapter 3, Article 5 of this title. What I did is I looked it up, and it has to do with the parent education class. I've done it. In addition to that, so that's why number 10, father has attended many parenting classes and courses, including courses regarding co-parenting. He is currently sole legal guardian of mentally disabled or older daughter. Mother has not taken nearly half as many parenting classes as father has never taken a class or course regarding co-parenting. So there again, there's the rule, and there's me following it and making my argument. 11, whether either parent was convicted of an act of false reporting or child abuse or neglect under the section, and you can look it up if you want. I didn't. I looked it up just in case, but mother has made number 11 for mine. Mother has made false reports about father, all of which has been unsubstantiated. Mother has falsely accused father of kidnapping, of which there is no charge nor conviction of such towards father. Mother has been instructed by Judge Clark to stop using the term kidnapping when referring to father. Mother has falsely blamed father for her failures as a mother and her legal decision-making authority of daughter whom is in need of therapy, of which mother has failed to obtain for daughter. Number 12. There was no number 12. In a contested legal decision-making or parenting time case, the court shall make specific findings on the record about all relevant factors and reasons for which the decision is made. All right. So, any lack of agreements to date has been due to the mother's unwillingness to compromise and co-parent, is evidenced by several attempts by father over the years to co-parent, including contacting mother through her counsel, as evidenced by email exchanges. Each time the mother has chosen not to compromise, chose instead to cause conflict, and then have their claims dismissed time and time again. So, there was a previous order in play, and I put down my argument as to why that wasn't the best order for such. So I put down my argument for the order because at the current time, there was an order that was in place, right? So whenever there's an order, there's one in place until it gets changed. And so your argument is for the new order, and then you could also make your argument against the previous order, like, hey, like we need to change this, right? So, and I put down that it's not in the best interest, and I made my argument regarding that there was no continuing increase in parenting time for father and was stagnant, in which it would permanently keep father as an every other weekend visitor with daughter and did not have any overnights. This order was also flawed in the sense that it was reliant on there being some kind of co-parenting between mother and father. The mother refuses to co-parent. And, so then we talk about out-of-state travel, passports, mother obtaining a passport illegally, and then I bring up the mental health evaluation, and then I put down my reasons for legal decision-making authority, and 50% equal time. All right, so father has already raised a child, has already successfully co-parented with mother of other daughters, so legal decision maker, so legal guardian. Father's guardianship case is of court record. So basically, I'm pointing out legal decision making authority and what it entails. Legal decision making has to do with um, health, mental, physical health, doctor's appointments, school, all of those things, right? Like basically the daily needs, the ongoing health needs, all of those things. Okay, so here's my argument. I already do this. I already do this because I'm sole legal guardian of my oldest daughter. I have a mentally disabled, older daughter. So I've already done this. I've always been the better parent in this whole scenario. I just didn't have the attorney and I didn't know their rules when I first started out. I didn't know. So I failed drastically first time coming out. And this whole time, I'm just trying to make up for all that. I'm just barely trying to get back to where it should have been at the beginning. But because of my massive failures in the very beginning, I'm working my way back. I'm working my way back. What I didn't do was give up. That's what I didn't do. And it sucks to those of you that did. All I can say is your kids are counting on you. Your kids are counting on you not to give up. Okay? So from then, I was very specific as far as what I would do. I would enroll my daughter in the school across the street. It would make I would be more available to her. I would be able to pick her up right when she got out of school instead of her being in an after school daycare program where she was at and she stays there till it's dark. And it's just nonsense. What is okay that they let the mother do. Like they'd rather that the mother have the daughter with the babysitter instead of with her father. And again, that's why all of this is just so ridiculous. It's so ridiculous, and it's nothing but money to feed the machine. The machine of family court and their fraud. That's all it is. It's all about money to them. They don't care about the children. They never have. They never will. So in the parenting plan, in accordance with continuing of the statute, there was a parenting plan that I had to put into place. So I had to describe the parenting plan, and I used the code Arizona Revised Statute 25-403.02 because I already did 25-403.01, 403 this here. So this is like the first one, the main one, and then after that, this is 2, right, where there should be a parenting plan. So I already submitted a parenting plan. We went over that and just basically outlining that adopt a parenting plan that provides for both parents to share legal decision making with the child, maximizes their respective parenting time. And I outlined that in the parenting plan, and also saying that I have support by way of my side of the family, and she's being deprived of father's side of the family. I'm of sound mind, mental health, make rational and logical decisions. I bring up her mental health issues again, saying that I would follow the law, whereas I wouldn't illegally obtain a passport like her mother did. I wouldn't commit violence like what her mother did on my sister. Again, I bring up mother should take a mental health evaluation, and she needs parenting classes, and court should consider father's position and focus of daughter's best interest, and any shifting of father's intent would only be to address defending myself should the mother and her attorney continue to attack father and make false accusations. Okay, so so I was making my argument for and then my argument against. Okay, and then the next statute, 25-403.01, parents' lack of agreement is unreasonable or influenced by an issue not related to the child's best interest. And I'm saying the court must ensure not to default to mother having legal decision-making authority because father and mother do not agree, and instead must focus on which parent is causing the disagreement and refuse to compromise, which is a tactic that the mother uses to convince the court to maintain legal decision-making authority. Because the court's position is, if both the parents don't get along, only one of them can make decisions. Okay, so all the mother has to do is not get along with me, and she gets to keep legal decision making. It's stupid, isn't it? But this is what the court allows. This is what they do. This is what they do. Okay? We don't matter. Okay, guys? We don't matter. As fathers, we don't matter in court. I'm sure you know this already, and you could still see how this bothers me. But when it came down to my paperwork, when it came down to how I handled myself in court, I was all business. I was all strategy. Okay? I get to feel the way I feel right now, but it's not going to affect my strategy. All right? So make sure you try and separate the two when you go into court and fight for your kids. So I move on. There's the statute again. If this is too boring for some of y'all, that's okay. You can cut it off or whatever. I get it. We're diving really deep into the statute. We're diving really deep into the details and putting together the arguments and your paperwork and this and that. And I get it that it's my situation and it's not yours and whatever. That's fine. That's fine. You know what I mean? Like, I just, maybe there's someone there that doesn't know how to put this together and how they're supposed to make their arguments and how they're supposed to present this in court, what they're supposed to do and what they're supposed to follow. And if it's only a couple of you guys, then great. I'm glad I was able to help you out. All right. So I have plenty of other videos. All right. So I told you this would be detailed. So then we proceed whether joint legal decision-making arrangement is logistically possible. Right here, I'm just going to point out where I'm at just in case. That's where I'm at. So because, and that's ARS 25403.01, it's in a continuation of the statute. And number 4, that's number 4 in the row of whether it's possible. Because of the self-serving strategy by mother and her attorney, it is not in mother's best interest to co-parent and compromise with father, because doing so will have the court believe that the mother and father can share legal custody and decision-making authority. The mother has insisted in her filings, and they filed this, a Rule 83 motion, a Rule 84 motion, and a Rule 85 motion within the last year, that the father is nothing more than a playmate with daughter and would like to see more fatherly duties of father. That was what they were saying. They contradict themselves so much. So much. It's so ridiculous. Like there's nothing, just so you know, there is no shame and no insults an attorney wouldn't do in order to do whatever they can get for their client. So since we're the logical ones, and we're the ones that want to compromise. We're the ones that want to do 50-50. We're the ones that want to do equal time. We are the ones that always want to do what's best. Just know that the mother could give a fuck less, and the attorney wants money. So therefore, you have to fight fire with fire. Okay? Because in the documents, be aggressive. Be aggressive, swing for the fences, because they're going to make you out to be a piece of shit. And they don't give a damn about the kids. They're going to do it. So that's what the baby mama kept doing. She'd call me, oh, I'm a playmate. Oh, I was like, all right, so you think I need more fatherly duties? Well, here you go. Here's the perfect opportunity for just that. Father seeking legal decision-making authority to drop daughter off at school, pick daughter up, cook breakfast, lunch, dinner for daughter, make doctor's appointments, get daughter ready for bed, and more. Since this argument was presented by the mother for father to take on more fatherly duties, then the mother should have no reason to respond to this modification, and in fact, wholeheartedly agree for father to have legal decision-making authority and 50% equal time. Unless, of course, the mother was just misleading the court and making a false claim to minimize the phenomenal parenting skills from father in order to convince the court to restrict the father's parenting time. Of course. So I made my argument for and against in case of their argument against. Like, I left no room for them to say, basically, just no room for them to say that I can't spend more time with my daughter. So the court should be interested in listening to mother under oath and the penalty of perjury of mother's intent regarding the argument that mother made requesting father take on more fatherly duties, and why mother would then turn around and challenge this modification for legal decision making and parenting time. So I continue with the statute. Number 3, the past, present, future abilities of the parents to cooperate in decision making about the child to the extent required by order of this joint legal decision making. And I point out again, the court must not allow the mother to benefit from the mother's intent to continuously cause conflict. The court is obligated under the law to do what's best for daughter. The mother has had 7 years of legal decision-making authority, and she has failed daughter. Father has years of experience making legal decision-making for oldest daughter, including doctor's appointments, therapy, triage, school, medical reviews for mental and physical health, medical maintenance, short-term and long-term care service plans with providers and group home facilities, short-term and long-term care service plans with division developmental disabilities, court orders regarding guardianship, reporting, care, financial management, and much more. The best interest of daughter is for her to have equal time with both parents. That is law and best possible scenario for every child. And here's where I invoke the Supreme Court case law. Actually, this is appellate court case law, and I threw this in here because this is Arizona law, right? Because if we're using Arizona statutes, I'm using Arizona law. All right. We're not talking about a constitutional issue like parental rights termination. That's not what's happening here. I'm not being deprived of my daughter. I'm just being deprived a certain amount. Constitutionally, when it comes to parents' rights and all these court rulings, it has to do with parental termination. This is not a parental termination matter, so that's why I had to use the appropriate case law for the appropriate matter. So this was just a request for equal time. So I used the Supreme Court case law as general rule, or near equal parenting time is presumed to be in the child's best interest. Maricopa's County juvenile action, and there's the case law. A father has a right to co-equal custody of his child, but not exclusive absent a court order to that effect. Thus, the court errs as a matter of law when it applies a presumption against equal parenting time. So that's what I was going for, and that's the law that I used. And then, I just surmise with the risk factors. So the risk factors that have countless facts and statistics prove that a fatherless home is detrimental to a child's well-being, future mental and physical health. The mother wants daughter to intentionally be at an at-risk category, which has now manifested in child's and daughter's behaviors and recommendations of therapy. No reasonable man or woman could possibly conclude that in every other weekend father is what's best for a child, when there's absolutely no statistic or fact that supports that theory. If this court cannot rule 50-50 equal time between mother and father, then this court is obligated to make a finding that daughter would suffer a harm with being with father 50% of the time that would supersede the harm that is currently being caused to her by being fatherless, which is supported by every statistical fact amongst problems with children raised in single-parent homes. And there was my closing. All right. So I submitted this in my parenting plan, and I got a response from them. This is the nonsense that they sent me. All right. So they respond back. This is the nonsense they sent me. First of all, they were alleging that it hadn't been a year's time. They, this is an attorney strategy. An attorney went to law school for 8 years. He knows what the rules are. He knows what the statutes are. He knows. He knows. But they're the stupidest people alive that is allowed to get away with anything and everything in court. Why? Because they always pretend they didn't understand. They always pretend that it was interpreted differently. They pretend, and they get away with it. They get away with it. This is why I'm telling you. This is why I know for a fact that they treat me differently, because I don't participate in monetarily in their stupid little game. Okay? Because I don't pay for an attorney to play the way that they want to play. And because I didn't pay for law school, and because I didn't pay to contribute to their nonsense. No. All I did was study the rules. I used the rules, and they didn't like that I didn't use an attorney. So, here's the baby mama with their response to my petition for modification of legal decision making and parenting time. They're saying that I filed a modification that is premature. That's a goddamn lie, and they know it. But this is the nonsense that they're allowed to do. I'm telling you, it gets really frustrating. It gets really frustrating. They're saying that I cited my pleadings that the last order for legal decision making and parenting time was issued October 24, 2022, which was true. Pursuant to the minute entry and orders by this court on October 25th, 2023, the ruling legal decision making parenting time was issued, and a parenting plan based on petitioner's performance and compliance with the court orders was outlined in detail. In those orders, there was a directive to return to the parenting plan November 8. As this parenting plan was made by the court on October 25th, the plan cannot be changed until October 25th, 2024. That's a lie. That's a lie. They were there at the hearing. In fact, I uploaded the hearing. I uploaded the hearing that the judge said they are making an order based on a Rule 85 motion. Rule 85 motion is a change to an order. He knows this. They know this. But they're still allowed to file this fraudulent, frivolous nonsense. All right? It's frustrating. Pursuant to Arizona family law procedures, person should not modify parenting time decree earlier than 1 year unless the court permits it based on affidavits. There's been no exigent circumstances or major changes that would warrant the court to change the parenting plan. Just want to do this so you can see where we're at. And set that is contingent based on the petitioner's compliance with the conditions set in place. Parenting plan proposed and submitted by the petitioner with the petition for modification is fashioned like that of a 50-50 parenting plan, which has never been in place in this matter due to the petitioner's conduct through the years. 50-50 plan is historically a plan that is both earned and agreed upon by the parties. He's citing no case law here. Due to the petitioner's past conduct, there's no reason to believe he would or could be trusted to care for the child. See, now he's using would or could. He's using past, present, and future relationship. Although he didn't cite it, I know what he's using. The petitioner has asked for sole legal decision-making authority be given to him. Throughout the course of this matter, the court, through multiple judges, has continued to award sole legal decision-making to the mother, referencing the rule by Judge Sklar. These rulings have been based on petitioner's conduct in court, his refusal to follow court orders, his tone of communications between himself and the respondent, the fact that Mr. Quintero intentionally misled the court. Testimony was given, proving in trial of this matter the petitioner has attempted to modify medical records and to portray in a positive light. The court finds it necessary to protect both the daughter and mother from further harm because of the risk foreseen further custodial interference or kidnapping of the the petitioner, as a result of the court findings, it was made that the respondent was continue with sole legal decision making. They're just making their argument, except it's just full of lies, though. February 5th, petitioner dropped off a pleading entitled Motion to Enforce Respondent to Abide by Arizona Child Safety Laws. Yeah, because I caught the baby mama transferring daughter without a child seat. You know what even makes it more frustrating is that she got away with it, and the only thing that they did was put in the order that they need to have a child seat. That was it. That was it. And that was even more frustrating, that she just blatantly doesn't follow the rules, blatantly endangers my daughter, just blatantly does it, gets caught. I submit the evidence, and it means nothing. It doesn't matter. It doesn't matter, so I get it. I get it. It's extremely frustrating. You guys send me emails, and it's frustrating. You guys are frustrated. You feel the way you do. I get it. I've been there. I'm there. I continue to go through it as long as this woman is basically just, until my daughter's 18. Baby mama's just going to be a headache, because she's never ever going to do what's best for our daughter. She's never going to do it. Never has, and she doesn't care. I've accepted it. I've accepted it. But that doesn't mean that it doesn't suck to feel that. So that's what she did. She transported our daughter without a child safety seat. And I caught her, I filmed it, and I showed the court. And she lied about it. She lied under oath. And the court did nothing. The court did nothing about it. They don't care. So he has proceeded to claim that he made a police report, however, citing no report number, name of the officer, or proof of the report. He claims an officer told him to withhold the child from mother until the car seat was in place. Petitioner checked photos of the child with the respondent backseat on 4 different occasions, only one of which showed the backseat of the vehicle. He has also included a report from the 5 inches counselor that has documented the respondent did have a booster seat. This is just lies. Lies. Petitioner acknowledged in his motion that it was in fact vexatious by saying petitioner is not trying to be vexatious. He literally contradicted himself here. They don't care. They don't care. Fight fire with fire. When you're just about to enter into a divorce and you're telling me that your baby mama is reasonable, no, she's not. No, she's not, because she's about to take your children and everything from you. Do not believe these women. He went on to claim the respondent possibly not having a booster seat in her vehicle, and was new evidence the respondent's reckless and unreasonable behavior. Therefore, is reason to have legal decision making for the respondent to have a mental evaluation. The petitioner once again takes a giant leap from possibly not having a car seat in the vehicle to his continual claims that the respondent needs a mental evaluation. She does. She's a goddamn psychopath. And she's been already diagnosed with mental issues. Returning to the rulings from October 24, 2022, the court has no serious issues about her health, because, of course, again, the court doesn't care. Court doesn't care about the baby mama. They're going to just, they're just going to continue to be on the mother's side, no matter what, because I presented a perfect case. And showed all the nonsense and violence and mental issues with the baby mama. And still, they chose to side with the mother. Don't get me wrong. I got some things in the ruling, which I'll show you, which I call a win. Of course, I got a win if I got some things instead of, what they wanted, which was nothing. So, while the relationship that's me has caused her extraordinary stress, that does not reflect on her fitness as a parent. Just nonsense. Wherefore, this is what they asked for. Respondent respectfully requests that the court enter the following order. So, when you put down your petition or whatever it is you ask for at the end of it, you make your arguments throughout, and then at the end of it, you put down what it is you want. So here it is. They want an order denying the petitioner's petition for modification, order that respondent retains sole legal decision making, order that the child reside primarily with respondent, order that the petitioner must comply with the parenting plan put in place, order that the petitioner pay all respondent's attorney's fees and costs in this matter, given his unreasonable conduct and fees respondents had to incur as a result. He should take further unreasonable positions of litigation in this matter in order for such and further relief as the court seems just and appropriate. And there's his nonsense right there. All right. And was their response. There it is. And the judge granted my petition. Fuck off. And we had hearing. Now we're going to get into that.